Thank you, Madam Speaker. And I'm rising at this hour to speak to the programming motion on Bill C-22. And having heard the speeches of a number of colleagues in this place with whom I agree, my colleague from the Bloc Québécois particularly, and my colleague from the New Democratic Party, as someone, as I explained earlier in answer to an earlier discussion with the Honourable Member for Vancouver East, the position we were in as members not of the committee but as members of Parliament with the right to participate in the development of amendments, although not full members of the committee, our participation in the Public Safety Committee, and I speak of we being the member for Vancouver East and myself, was more limited than those members who are full members of the committee. But I have been very concerned, and I'd like to say it from the very beginning, with last June 2025's tabling of Bill C-2, the so-called Strong Borders Act, the astonishing, broad, deep coalition of groups, over 300, who came together to oppose that on many grounds relating to human rights, as well as privacy, as well as overreach. And again, I just want to preface my discussion of Bill C-22 by placing it for citizens watching this in the context of how did we move from a C-2 Strong Borders Act in June of 2025 that was strongly opposed. I don't think I've ever seen quite as a diverse coalition. Certainly there's some bills that invite lots of organizations to get involved and individual citizens to get involved, but this was a breadth and a depth that was certainly unusual. The government realized it was in trouble. There was so much opposition to C-2. And when we came back in the fall, I thought to myself, well, this bill over the course of the summer has been dumped, and C-2 is replaced, and now we have C-12, and it's a completely different bill. Well, it wasn't completely different. It was largely the same language of chunks of what was in the Strong Borders Act C-2, but taking out the parts that were overreach into privacy that were, for instance, the sections originally in C-2 that said such things as that that postal workers could open the mail. There were a number of examples that got dropped. But the thing that's unusual about this, Madam Speaker, and I know it's complicated and I know the hour is late, but why would a government introduce a bill that's widely panned and then bring in a different bill as opposed to amending the bill that it already had on the order paper? I've not seen this before. And then in bringing in the bill that had most of what was in the Strong Borders Act in C-12, continued to leave C-2 on the order paper and continue to force through C-12, which I do believe does, and we'll see, time will tell when it's challenged in the courts globally because it violates our charter commitments in protection of refugee rights, and I speak of that in terms of the Global Convention on Refugees. It may also offend the Canadian Charter of Rights and Freedoms, but I'm speaking globally of what the pulling out from under people who had expectations as being in Canada, but they didn't know their access to claim refugee rights would be taken away so abruptly. In any case, this has been bizarre. So we had C-2, it stayed on the order paper. C-12, which was largely language from C-2, and then it was pushed through. And the whole time I thought, well, at least we've avoided the surveillance concerns, the privacy concerns, the overreach concerns that were evident from the original C-2 Strong Borders Act. But then no, and come to April of, it was actually March 12th of 2026, that we have the bill that's before us tonight, Bill C-22, which again is the government at this point third run at crafting a bill that deals with lawful access. Well, I'll give them this. C-12 actually avoided the lawful access sections and just focused on the portions that affected refugee rights. That one still grieves me, the fact that we would have Bill C-12 pushed through to final stages on a unanimous consent motion in this place last June. So I really still regret very much, Madam Speaker, that was pushed through. This is a conversation and a phrase you'll hear from opposition members tonight, and you've heard it often, pushed through. rushed through. This is not hyperbole from opposition members. This is an experience of experienced members of Parliament. I've been here 15 years, and I'm honored to have been so, but I've never, to my honorable colleagues on the other benches in the government party, this has been a shock to see how often we see things when mistakes are identified. Previous governments have been more willing to say, we have a mistake, and we're going to have to rethink this. This is a mistake, and we're going to amend the bill. We're going to say where we made the mistake and how we're going to change it. But this government is quite unusual in not admitting mistakes, but bringing in a different bill that does some of the same things, and then now this is the third run at it. Well, Madam Speaker, this lawful access regime has many improvements over the lawful access regime of C-2. No question, no doubt. There have been significant changes, and and I think every group that was in the original coalition opposing C-2 has said this bill, C-22, is much better. We have fewer problems with it, but there are very serious problems with it. And that's why it's lamentable that we weren't able to have the kind of conversation one would have with a government that was more comfortable in its skin to say we made a mistake with C-2. We pushed too hard, too far, too fast. Now we're going to listen to people. And as we craft a lawful access regime, we're going to really listen. And we're not going to assume we have it right because we are right, because we have the majority, so we're right. This has been very difficult to observe, and certainly in committee. I have to say I was surprised. I was taken aback that as reasonable a request that we have before the Public Safety Committee, the Privacy Commissioner who had raised concerns. We had a lot of witnesses who were there who represented government agencies and law enforcement to provide technical background. I couldn't see, and I try to be as nonpartisan as possible, I couldn't see any problem with getting the expertise of the Privacy Commissioner in the room as members are discussing and debating the impact of C-22, whether some amendments should work, how they should work. It was rejected, the idea that the Privacy Commissioner should be in the room. I couldn't see in any world in which that wouldn't have been seen as helpful, but it was rejected. I have some amendments before the committee. We'll get to them later this evening once this, and I don't think it's anything but a foregone conclusion that the motion before us is going to pass. But I lament that we have seen this, and it is a pattern of moving very, very fast and passing legislation despite significant concerns from significant quarters. So again, I'm not using it as a prop, Madam Speaker, it's just for reference, that a very significant number of respected law professors and experts in privacy law and constitutional law wrote as recently as last month to basically most of the cabinet to express their deep concerns about Bill C-22, that they feel as though, again, they acknowledge, and I think it's important to say, people are not just partisan here, certainly law professors aren't, they see the improvement over C-2 in numbers of areas, but they say clearly, and I'm going to quote from this letter that was signed by multiple, 20 or 30 law professors from across Canada, dated May 4th, so that anyone who's looking for it can find it. But they say, we write as lawyers and law professors who teach and practice in the areas of privacy law and constitutional rights. I'm going to skip ahead to their conclusion. Provisions of the bill as currently drafted raise serious constitutional concerns and fail to strike a reasonable balance between the reasonable and legitimate needs of law enforcement and the privacy rights of Canadians. Again, these are not the voices of those who've been misinformed through social media. These are people of depth and knowledge and experience, and they're very concerned. Just yesterday, one of Canada's sort of premier policy wonk magazines, Policy Options, I don't speak of them pejoratively here, but Policy Options is not something you pick up in the supermarket. Inquiring minds want to know. Policy options is serious. And there was an article just yesterday by Professor Cynthia Koo, who's a professor at University of Toronto and a senior fellow at the Citizen Lab at University of Toronto, and also, so she's an expert in both technology and privacy areas. Her conclusion was Ottawa should reject any data sharing arrangement that allows U.S. law enforcement to access Canadians' personal information. Now, this is based on recent research within the Citizen Lab that the regime for surveillance as being established by C-22 could provide easy access for instance, U.S. Homeland Security to the private information of Canadians. I know the government benches have heard and don't want to hear anything more from Professor Michael Geist, but again, a prominent critic of Bill C-22, starting with his opposition to Bill C-2, what he pointed out is that what he sees being spread by the government benches, he describes as misinformation, mischaracterization, overly broad definitions, and failure to be precise in areas where you really have to be precise. And what he said is political pressure, I'm just going to quote from his, from a blog he posted recently. Political pressure against Bill C-22 has been steadily mounting with opposition parties, as you can see all the opposition parties in this place, tech companies and privacy experts, all increasingly concerned about the need to amend this bill, increasingly concerned about that all the government seems to have in response to the criticisms is, in his words, misleading or inaccurate claims with little in the way of an actual defense based on the facts. His conclusion, the government's disregard for facts and privacy is fast becoming C-22's legacy. Now, the criticisms come, again, from a broad sweep of legal and privacy and tech experts. They're not all the same. I practice law, and technology is not my area. I wouldn't put myself out there as an expert in technology. I read deeply. But I am concerned about constitutional rights and privacy as a former practicing lawyer. But it would seem to me that anyone with background in the various areas that are touched by C-22 would want to take the time to get it right. There have been things claimed that all our Five Eyes partners have legislation just like that, just like C-22. That's been debunked by numerous experts. We've been told that it was wrong to take a long time in committee. And I'll obviously, as someone who has, as my honorable colleague on the other side, Parliamentary Secretary to Minister of Finance, knows well that we had a very lengthy filibuster in C-30, and in the Finance Committee, I sit through those evenings waiting for the chance to speak to my amendments, which, as I mentioned earlier, Madam Speaker, the motions that are passed by committees as if they're normal, and they're not normal at all, but the longer they're used, I guess the more future committees will just assume, as every committee did after this last election, that this is just normal to take away the rights of the smaller parties so that the larger parties don't have to fuss with them at report stage. That's the case, Madam Speaker. If it wasn't for the motions that were passed by committees without thinking about them, taking away the rights of smaller parties, I would have the right to put forward amendments at report stage. I only don't have that right at report stage because I'm given this so-called opportunity to work really, really hard to bring forward amendments that give me the ability to sit in a room and not speak for days at a time, hoping for the chance to speak to the one or two amendments I've brought forward. And I do want to thank my honorable colleague from Vancouver East from the New Democratic Party, because she's in the same boat and she brought forward many more amendments to C-22 than I brought forward on C-22. I think I was too busy trying to write amendments on Bill C-30, but in any case, what we have here is not just an imperfect bill, but a potentially dangerous bill. And we're now down to the final moments. The clock is ticking, and the words of the experts from across Canada are being shut out because the government has determined it will move forward with C-22. That's why we have a programming motion, to make sure that we don't have any further debate on the amendments that have been put forward by members of the Conservative Party, the Bloc Québécois, the Greens, and the New Democrats. We're in a hurry. And again, I have to push back and ask why. What's the hurry? What's the rush? The first attempt, just as a reminder, that this government made to bring forward lawful access was in a very outrageously and overreaching Bill C-2 a year ago. So a year has passed. One would have hoped that year would have been used well by allowing a real discussion and continually striving to have the best possible surveillance architecture to protect privacy, give law enforcement what it needs, without tests of access that are so low that reasonable ground to suspect that we don't think the courts will find to have been an adequate ground to seize personal information. The concerns that we're hearing, again, from tech companies and constitutional and privacy law experts, and those who work in the field, and those who have, whether open media, I'm honored to claim that the executive director of Open Media happens to be one of my constituents, so I also speak on behalf of my constituents when I stand here at this hour. Yet, those voices seem to have just gotten annoying to the members of the government. They don't seem to be concerned that despite all the work and a full year that's gone by, that we could get this right. And again, we hear, well, we run out of time. Well, we haven't. I don't think any of us are going to expire in any particular moment. We could meet next week. We could we could actually get together again and have more time for witnesses to actually discuss, not on with a clock ticking, but for members, for witnesses and experts to actually share with the members of the committee in a respectful way, can we improve this? Now, we've just heard, and I saw the honourable member for Barrie mention it, Barrie Innisfil mentioned it earlier, we're seeing news across the news wires that the Minister of Public Safety is about to make a step. And now, of course, who knows, but certainly it wasn't the National Enquirer, it was at least CBC, saying that the Government of Canada is prepared to fundamentally change one aspect of this, not having to hold Canadians' private data for a year, but maybe bring that down to 6 months. Is that going to be presented? I don't know. We're going to be going into committee after the programming motion is passed. There will be an opportunity for new amendments to be tabled, not, of course, from me or from the member for Vancouver East, because we had a deadline some time ago, and we either bring it in by that deadline or we don't bring in something new. So there may still be that opportunity to improve the bill. I certainly hope so, because what we have in front of us may violate our own Charter of Rights and Freedoms, open up personal data, surveillance data, do serious damage, and if, good heavens, if the Citizen Lab research is right and Canadians' private data is available to U.S. Homeland Security folks in large tranches, none of us are going to feel particularly happy about that. Our government should be making sure that our privacy is protected. It's an inherent right that we have. I'd like to say it's a right the way First Nations have the right to clean drinking water, although we've now been informed that they don't have the right to that, but only the hope of, what is it, that term? It's just so extraordinary. A gradual realization, eventual realization of a right. Well, we have a right to privacy, and I don't want to hear that it's dialed back to a gradual realization of a right. We have a right to privacy. We can reasonably expect it of our government to ensure our private data is not left in an architecture of surveillance that allows it to be accessed by foreign governments, any foreign government. The Citizen Lab data research that was just published in Policy Options yesterday talks about U.S. Homeland Security as an example. But I don't want my government asking tech companies to save and store and access private data about Canadians that's then available to foreign governments. We've certainly learned a lot about foreign interference, and we're waiting for the foreign interference and the foreign interference registry to actually be established since we passed that law some time ago. But at this late hour, Madam Speaker, and I know I'm out of time.
The honourable member is over. is done with